The broadcast is now starting. All attendees are in listen-only mode.
And good morning, and welcome to today's webinar entitled Romance in the Workplace, or Office Dating Pools Need Lifeguards Too. My name is Marvin Schwartz. I'm the COO at American Chamber of Commerce Resources and HRSimple.com, and welcome. Just a little bit about what's going to happen here today. Our presentation lasts about 60 minutes. At the end, we will provide you with SHRM and HRCI codes at the end of the webinar. You can also enter any questions in your chat box that you have, as well as, whoops, hit the wrong button at the wrong time. In a few days on youtube.com/HRSimple, this webinar will be up there in its entirety. Our webinar today will be by Greg Grisham. He's from the Memphis office of Fisher Phillips, and Fisher and Phillips, they write a whole bunch of our books, including the South Carolina Employment Law Reference Guide, the OSHA Workplace Safety and Health Compliance Manual, as well as our Missouri Model Policies and Forms and our Kansas Model Policies and Forms. Greg Grisham himself is of counsel in the Memphis office for over 25 years. Greg has successfully counseled and represented employers in all areas of labor and employment law. And additionally, he regularly speaks at public seminars on workplace law issues and authors numerous articles on labor and employment law topics. Like I said, today's webinar will begin in 60 minutes. I will provide Greg's email address as well as my email address at the end. So if you would like slides or anything else of the presentation, feel free to email us when it's all done. And without any further ado, let me see. Greg, are you there?
Yes. Can you hear me okay, Marvin?
I can hear you just fine. Give me 1 second here. Whoops, hold on. Here we go. I'm going to pass this over to Greg Grisham, and he will take you through everything.
All right. Well, thank you very much. Could I ask you, Marvin, is it coming? Is it showing up full screen on your monitor?
Right now, you have to click that Change Presenter button.
Okay. Okay. Do you see it?
Not yet. Let me try this again.
Okay. Can you see it now?
I am seeing your screen, yes, but I'm seeing your computer. Sorry for the technical glitch, guys. We try to get this worked out each and every time, and there's always a new wrinkle every time.
Okay.
Yeah, I can see your screen. So.
Okay. All right. Ready to go. All right. Thanks, ladies and gentlemen, for attending the webinar today. As Marvin said, I'm Greg Grisham. I'm an attorney with Fisher Phillips in Memphis. I've been 2019 is my 30th year in law practice. So there are probably a few things I haven't seen, but I've seen just about everything, including all types of sexual harassment cases, both from an investigation standpoint, from a claims handling standpoint. And I think today's topic is an important one, particularly as we get closer to Valentine's Day, where where people are focused on romance. And we're going to go through a number of slides today, and hopefully you'll learn something today. During the presentation, if you have questions, please let us know, and we'll do our best to try to answer those as we go along. All right, first of all, Marvin, is the screen moving?
I am not seeing your PowerPoint at all. I'm just seeing your desktop, actually.
Okay. All right, can you see it now?
No, I just see you moving around your desktop.
All right, Sorry about that.
It's all right. Here we go. Now, if you want to go ahead and put it full screen, you'll be all set.
All right. All right, can you see it okay now?
Yeah, but you're still not on full screen. But we hit slideshow.
Yeah, that's what I did.
All right, we can at least still see it. So go ahead.
Okay. All right. Well, very good. Folks, let's look at some statistics. You know, all of us know. I personally, I guess, in my younger days before I became a lawyer, may have dated prior to working at a law firm, may have had an office romance or two along the way. Many of you probably maybe have too. But one thing that's pretty clear, the workplace is a very common place where people meet. You know, you spend probably more time at work than you do outside work, or at least it's probably equivalent. So if you look at the Career Builder, this is a survey from last year. You can see that office romance has come down a little bit, and this may be because of the Me Too movement that we'll talk about here shortly. But you can see that 22% of workers have dated their boss, which, you know, is a bit problematic sometimes from a sexual harassment standpoint. You can see 1 in 10 female workers whose romance work soured left their jobs. And one stat of concern is 41% of workers had to keep their romance secret. So there's a lot of romance going on in the workplace. Another interesting survey, this is a different survey from 2017, says that 57% of the people that were surveyed, responded to the survey, participated in some kind of office romance. Only 16% of them led to long-term relationships. So it's fair to say that while there are a lot of office romances that occur, most of them, you know, don't either end well or at least end in a long-term relationship. I'll have to say, during my legal career, that a big number, not all, but a big number, maybe the majority of sexual harassment and retaliation cases have come out of dating relationships gone bad. It's not only supervisors dating people that are under them or who work for the employer, but also coworkers. And now today, in this era of social media with Facebook and other social media forums, you see sometimes harassment types of issues arising on Facebook, where people, make bad comments on Facebook pages, say things. So it's become more complicated for employers today than it was, 10 or 20 years ago, and trying to maintain a workplace and enforce their policies in the workplace. Now, once again, you have sometimes office romances turn out well. I thought this was kind of interesting. The five famous office romances, the greatest and worst hits. President and First Lady Michelle Obama actually met at work when they were both attorneys in Chicago when they were starting out. And so, of course, we all know that turned out well. They have a very good marriage and get along well. We all know about the unfortunate experience of Bill Clinton and Monica Lewinsky relationship that happened, that many of us on the call can remember that back in the 90s. That didn't turn out very well. Bill and Melinda Gates, another example, like the Obamas, of people he met at work at Microsoft, and they're happily married and involved together in a lot of philanthropic enterprises. Of course, they're heavily involved with Microsoft. David Letterman, many of us on the call probably, I know I used to enjoy watching the David Letterman show. He had a relationship with it came out that he had a relationship with a number of females who were working there, and one in particular uh, it became a bit of a problem because apparently the ex-boyfriend of this individual allegedly blackmailed Letterman, and anyway, it was a big hullaboo about that, and Letterman did admit it. The most sort of bizarre relationship on here, the NASA relationship. This was, I don't know how many years ago this occurred, but two astronauts who were both married began a relationship that went on for 3 years, and it didn't end very well. The male astronaut dumped the female astronaut. He also dumped his wife and took up with somebody else. And the bizarre twist here is the female astronaut who was jilted drove from Texas to Florida and actually tried to hurt the girlfriend of the male astronaut. So so you can see here, you know, office romances, you have some that end up very well, but the majority of them seem to not end well or potentially lead to problems. So what is the legal exposure for employers for workplace romances or relationships in the workplace? Well, you know, employers today, in this litigious age we live in, it seems like it gets worse every year. There are a lot of potential claims that could arise. You know, of course, sexual harassment is the claim we're all reading about and hearing about today. We've been hearing about it for years. I know when I first got to law school, I remember the Clarence Thomas Supreme Court confirmation hearings, where that was the first time, at least, that it became widely known and people started talking more about it, although the law prior to that time had recognized sexual harassment as being a form of sex discrimination that was prohibited. The EOC had gender discrimination. Sometimes you have, you know, in the workplace you can have people treated badly simply because they happen to be male or female. And sometimes there's some romantic motivations there. It doesn't necessarily rise to the level of harassment, but if you start treating a person differently because of their gender, and it's not only limited to females. You see cases today, I've seen some big jury verdicts where males were harassing other males because they were males, is also something to be concerned about. Retaliation, we're going to have a section about that, full section about that shortly. That has become the most prevalent form of EOC charge and claim that we're seeing. You know, if you've got even a consensual relationship that ends, it's not uncommon for the jilted party to take some type of retaliatory action. And if the jilted party happens to be a supervisor, that's even more problematic for the employer. Assault and battery. Sometimes in these sexual harassment cases, you'll see the lawsuit will not only sue the employer, but also will sue the individual supervisor, claiming that the person was assaulted, there was some battery or assault committed, and those complicate the cases because those cases are harder to dismiss because it's a he said she said, and the way the law is in terms of how courts look at these things. If you have fact disputes, the courts don't like to just throw the case out. So those kinds of cases, if they don't get resolved, can often lead to trials. Defamation, libel, slander. You know, it's common sometimes in these cases to have somebody, you know, an allegation to be made of harassment, and the party who is the alleged harasser wants to sue the other party, wants to file a countersuit. So sometimes those claims percolate up in these cases. And then you can have breach of contract. You can have people that have employment contracts who get fired for harassment. I think recently we've seen in the news some pretty highly paid people in media who've been accused of sexual harassment who had contracts, you know, lucrative long-term contracts. And so you have contract issues sometimes that creep into these things that you have to consider. Now, what about personal liability? Well, typically under Title VII, which is the primary federal law that deals with harassment, there's not individual liability for supervisors. who allegedly engage in harassment or people. But you can, as I mentioned, have individual liability for assault and battery, defamation, things like that. Those are tort claims. And so the individual, is often sued individually. And once again, that complicates the handling of the case. There's some states, California is kind of notorious about having a lot of laws protective of employees. California recognizes personal liability for supervisors, and they also recognize strict liability in the event the supervisor engages in harassment. And there are also some other states, I believe Illinois is one, that has also recognized that. So we've got, potential legal claims against the employer. We've got potential legal claims against supervisors. Of course, the potential individual liability is always a good point to bring up in training. I know when I do training, I always spend time on that to try to scare, not only educate, but scare supervisors about the potential of being sued individually. So what are some other issues that come out of this? Well, if you have sexual harassment going on, or sometimes if you have romantic things occurring in the workplace, it can create a morale problem. If workers see certain workers being treated more favorably because they're in a relationship with the boss, they get discouraged. They think I'm not being evaluated based on the actual work I'm doing. So you can end up with morale problems, productivity problems. It's pretty common in cases. I've had cases where a few years ago had a case where a employee was performing badly, was a clerical employee, and was getting ready to be fired for poor performance. And in the exit interview, the employee said, well, my boss has been harassing me. And so we ended up having to deal with that and investigate it. So sometimes people that are in environments where harassment's going on, if they're the target or they see people targeted, or there's just, the focus is not on work, it's on romance, you can have productivity problems that occur. Attitude, workers that are in these environments, attitude and morale sort of kind of go hand in hand. Attitudes can become negative. Employees can start resenting the employer for permitting things to go on like that, which leads to another problem, employee retention. It's pretty common in workplaces where you have things like this happening. You see a lot of turnover. Some industries by nature have more turnover than others, but that's a sign that something's going on. If you see people leaving, if you've had a fairly stable workforce, it's a red flag that you need to look at. And recruiting, word gets out that your company's a place where harassment's going on, people aren't respected. It hurts recruiting. And today, we're in a situation where we have full employment essentially, and so it's harder to find people. So this is another problem, a real practical problem that can happen when these things are going on. So what is unlawful harassment? Well, I found today pretty much this word hostile environment, people understand it differently. A lot of people have their own subjective understanding of it. And so, there are people that think, well, it's a hostile environment because my supervisor told me to work or got on to me about something, but that's not unlawful. Unlawful harassment, that's not even harassment. That's just telling somebody to do their job. And as long as it's reasonable and within the normal boundaries of the workplace, getting on to people for not doing a good job certainly is something that you want your supervisors to do. There are two main types of harassment that we deal with in employment cases: quid pro quo. You don't see as many of these cases. It's good that you don't, because they're a lot more dangerous from a liability standpoint. It's basically having a supervisory employee telling a subordinate, well, if you date me or have sexual relations with me or whatever, I'm going to give you a promotion, I'm going to give you a raise, but if you don't, I'm not going to give you a raise, I'm going to give you a bad performance evaluation. So if you have the overture, and it's an unwelcome overture, and then you have something negative that happens like that, what's referred to as tangible employment action, that's, not getting a pay raise, getting fired, getting demoted, not getting a transfer that you want, getting transferred to a bad shift. That can be a tangible job. We also refer to as tangible job detriment. So that's a dangerous combination. And the Supreme Court has said that if you have that going on, if you have those things combined, then the employer is strictly liable for the conduct of the supervisor. Now, as a practical matter, if you're an employer, somebody makes a complaint and this has happened, what do? Well, you can mitigate the situation, and you should by, of course, investigating. And if you come to the conclusion that quid pro quo happened, it's not too late to try to fix it. You need to take appropriate action against the supervisor, which in those kinds of situations is very often and more nearly universally, you fire the supervisor. You make the person whole. You pay them any back pay they're entitled to, restore them to the job that they had before. Sometimes you, offer to pay for counseling. So if it happens, you don't want it to happen, but if it does, you need to be proactive and try to mitigate it. Because if you do, the person's going to have a much harder time convincing a lawyer, although lawyers seem to be everywhere, to take the case, because the damages at that point are going to be much, much reduced from what they would otherwise be. The hostile environment harassment, this is the vast majority of cases that we see. It's just it's just sort of from a common sense standpoint, it's just the environment really becomes poisoned by what's going on. And it's unwelcome behavior. Sometimes I've had clients call and say, well, we've got a problem, in this department, people joke with each other, they use bad language, everybody's involved with it. So you sometimes have behavior that goes on that seems to be welcome behavior, but there's always a person or two that's sort of stuck in the middle there that really doesn't appreciate it, that doesn't want to be involved. So you have to kind of drill down a little bit and see what's going on. But if you've got a lot of that behavior going on, even if people are participating, you need, if you're an employer, HR professional, you need to put a stop to it, because you've got to maintain discipline in the workplace. So don't let environments, even if the department's functioning well and productive, those kinds of environments can quickly get out of hand, and it's certainly inconsistent with the type of climate you're trying to have in the workplace. And also, so when unwelcome behavior is the first thing you look at. Also, is it offensive to a reasonable man or woman? There's some people who are offended pretty much at everything. If a supervisor says, well, hey, you look nice today or something, I discourage employers to discourage supervisors from even saying that today because of the environment we're operating in. But, that's not unlawful sexual harassment. It doesn't rise to the level, but people can get easily offended. So it has to be offensive to a reasonable person. So you also have some people who just have a thick skin, and so little things don't bother them. So there are some cases that say, well, it also has to subjectively offend the person, which, of course, if you want to gin up a complaint, the employee can certainly say that it bothered them. But reasonable man or woman is the standard that you look at. And it has to be severe or pervasive, either one. I sort of look at those being two sides of the same coin, but it's got to be something that sort of poisons the workplace, that changes the terms and conditions of employment. It makes the workplace, a place that people don't want to go to. And it goes to the fourth factor is it becomes an abusive working environment, really. So the third and fourth factors are sort of go hand in hand. There are a lot of court cases, which may surprise people, where the courts at least have a fairly high bar for that. You know, they require, if it's something fairly minor, a court's not going to, or a jury is not going to find liability. A court's probably going to throw it out before it ever gets to a jury. So it has to be, you know, a fairly high standard. But as an employer, you certainly don't want your workplace to ever even come close to that. So, and you certainly are entitled under the law to have a policy and enforce it in a way that behaviors that don't rise to illegal sexual harassment violate your policy. And so that's what you should try to do. You want to nip things in the bud before they become get out of hand. So it is a very dangerous scenario where you've got a working relationship. You've got a boss dating a subordinate at work, because what you see in these cases frequently is the person will, you know, and this may be their honest feeling about it, but you see people saying, well, you know, I felt compelled to be in this relationship. Didn't feel like I had a choice in the matter. So, you know, I felt forced to go along. So it really does create given how relationships sort of, most don't last, and people do see dollar signs when they watch the news and see people getting, you know, big settlements for harassment. It does create a dangerous environment for employers. So unlawful harassment, well, you can have harassment in different types of forms. And I break them down here: verbal harassment, physical harassment, visual harassment. And all three can be sexual harassment. Now what's verbal harassment? Well, the most, I guess the stereotype is, you know, someone asking for sexual favors. Now, you know, you can certainly ask somebody to go out on a date. If they tell you no, you just need to stop and don't ask anymore. But, you know, somebody that's persistent, that won't take no for an answer, that starts stalking, that keeps asking, that's a big red flag. Talking about sexual subjects at work, you know, getting personal with people. In these cases, you see a lot of that, a lot of questioning that goes on, which makes people uncomfortable. You know, there's a big difference in asking somebody, you know, did you have a nice weekend with your family, than start asking them about their, you know, their sexual experience with their partner. You can't have those kinds of conversations going on in the workplace. Also, comments about physical attributes. It's one thing to say somebody looks nice, but you know, saying things that, you know, make comments about a person's anatomy. Those kinds of comments, you know, are very dangerous if they're going on in the workplace. Name calling during fights. You know, we think about sexual harassment. That's really the big topic today. But, you know, you can have racial harassment. Here in Memphis, with the unfortunate history here, you've had a lot of race harassment cases over the years where people use racial epithets when they get angry. So you can have this name calling. You can have you know, terrible things said, which sort of are linked to some protected status that can happen, which can be a verbal type of harassment. Affection or demeaning nicknames. You know, you don't want, people need to be called by their names. Nicknames are not not particularly good. I've got a cousin who goes, his nickname is Bubba, and everybody calls him Bubba, but it's not his real name. But that's okay. He likes it, and it's not offensive to him. But, you know, you can come up with some nicknames, you know, that on their face are bad. They're offensive. And you can, sometimes people, to try to get control over somebody else, will come up with a nickname and sort of demeaning. So that's something that shouldn't go on in the workplace. Also, sharing opinions about stereotypes of people. Certainly, you don't want stereotyping to go in the workplace. We've got now under Title VII, you know, case law that says in some places, not in Tennessee or the Sixth Circuit, but a couple of circuits have recognized sexual orientation as being a protected type of sex discrimination. So using derogatory names for LGBT individuals, or making stereotypical statements. Those are very dangerous as well. Now, her claims of physical harassment, you see, once you get to that point, you have a lot more liability there. Using words is certainly not good, but once you get to the touching part, you can have a lot of people are more apt to file a claim when that goes on. And it's unwanted touching. I had a case years ago where the allegation was that the supervisor would brush up against people. A female would be at the copier, and the supervisor would walk by and rub up against them. It was a tight squeeze, but the person could have gone the other way. So that there was an allegation that that was unwanted touching. You can have violence. Unfortunately, in the workplace, we see more of that today. Grabbing somebody doesn't have to be a fatal type violence, but grabbing someone's hand or slapping someone's hand can happen when people get in arguments. Also, getting somebody in the room and blocking access, that by itself is a separate type of tort action called false imprisonment. But sometimes you see that going on. That's considered to be a physical form of harassment. Now, what about visual harassment? Well, today, probably all of us on the call, many of us on the call have smartphones that we all use for legitimate purposes. And, those of us that have kids wonder how we're going to get our kids to stop looking at their smartphone. I used to have a rule that at dinner, everybody's smartphone had to go up just so I could get their attention. But with a smartphone, it's pretty easy if you want to. It's your personal smartphone. You can pull up pornography if you want to. It's pretty easy to do it, and I've had cases over the years where people have, pulled up pornography on their smartphone or on their computer, start inviting people over to look at it. Now, those people tend to get fired pretty quickly, but, not everything gets reported immediately, so you can have that. Emails too, emails, text messages. Pretty much every sexual harassment case today has text messages where people say things that they wouldn't even put in an email. And with autocorrect, you can really get some interesting text messages that go back and forth. So photographs, leering. I had a case a couple of years ago where I got it dismissed, fortunately, because it was the person said that, well, he was being stared at in the workplace. But you can have, if it's leering, if you're just constantly looking at somebody, looking them up and down, that can be a form of visual harassment. And of course, exposing yourself. I had a case a few years ago where the allegation was that the supervisor adjusted himself in front of female employees, excessively, and that was a part of the basis for their sexual harassment claim, which we ended up having to go try. So these are some of the types of visual harassment that can happen in the workplace. Not a exhaustive list, but some pretty common examples. Now, we talked about automatic liability, where we have quid pro quo harassment, and we talked about what we can do to try to remedy it if it happens. But the Supreme Court, these were cases that happened many years ago, and that's well-established law that a quid pro quo type harassment, that the employer has to bear full responsibility for it. Now, who is a supervisor? Well, up until a few years ago, there was some debate as to whether someone could be a supervisor. In this case, this Vance Ball State case, as I recall, the question was, is a lead person who assigned work a supervisor? And the Supreme Court said no. The person who's alleged to be a supervisor has to have authority to carry out tangible employment actions. They have to have the authority to do something with respect to the alleged victim of the harassment, which are things, as we talked about, like granting pay raises, promotions, demotions, hiring, firing, those kinds of things. They have to have the ability to change the person's status. So if a person doesn't have that status, if they, lack that authority, they can still be evaluated if they're not a supervisor under at least a coworker standard for harassment, which is basically that the employer knew this was going on or was negligent in staying abreast of what was happening, which is still obviously, leads to the potential of being liable for it, but it's a different standard. And once again, tangible employment action, we talked about it. We think about hiring, firing, promotion, but it can be things like scheduling and also discipline, something less than firing. It can be writing somebody up or even coaching. Those kinds of things can trigger, it can be considered to be a tangible job action. Now, what about automatic liability? What do you do in hostile environment cases where you don't have this quid pro quo coming up? And we talked about what the standards are for determining whether there is a hostile environment for harassment. There are defenses if it is a hostile environment. But hopefully everybody on the call has a written sexual harassment policy that's been updated recently. That's really the first place to start if you're an employer, and we'll talk more about that in a minute. But if you're an employer and you don't have, I've had cases, I tried a case where the employer didn't have a sexual harassment policy, but they still, took it seriously, but the court would not permit us to have this instruct the jury because they didn't have a written policy. So if the employee doesn't take advantage of the policy that's there, and the employer takes action when they get a complaint or find out about it, the employer has the opportunity to say, well, hey, I shouldn't be liable in this situation. Now, you have some states like California where the company is always liable for harassment by a supervisor, whether it's quid pro quo or the hostile environment. So state laws become, while federal law, it's difficult to change federal law because of the division we have in government. A lot of states are pretty proactive, and the rule is the states can have laws that are more protective of employees than the federal law. They just can't have anything that's less restrictive or less protective. So if you're an employer and you operate in different states, it's important for you to be aware of the state law. And now we even have local laws. Local counties and cities have their own. We don't have any in Tennessee like that, but in a lot of places like California and New Jersey and places like that, you have a lot of cities and counties that have ordinances that can come in and you have to be aware of. So not only you have to know federal law and state law, now you have to know what the local law is if you're operating there. Now, what about the Me Too movement? Everybody on the call I know has heard the last couple of years about the Me Too movement, and it's been a very, very important movement. There are the Me Too movement really got kicked off with Harvey Weinstein, the actresses being harassed by Harvey Weinstein. So I think, Hollywood evidently just had didn't read these cases we've been going over. So it kind of got kicked off there, but it spread and it's become a national phenomenon now. And I think you can see this in the EOC stats for the last fiscal year, which ended in October. Harassment charges were up 12% from 2017, and harassment charges have been fairly level, have even declined a little bit. But this was the first annual increase in some time of harassment charges. You also had more harassment lawsuits filed by EOC. EOC doesn't sue for every case, but when they do, it's more difficult if you're an employer to defend it because you've got the full weight of the government, behind the EOC, as well as all the taxpayer dollars that fund what they're doing. So if you're an employer, you've got to deal with all that. It's a lot bigger hurdle to jump over. And what I've seen, at least, and this goes to the next point, reasonable cause findings. What we're seeing now across the country is harassment cases before the EOC would throw out. Now you're seeing reasonable cause findings on those cases. So sort of garden variety, what I would call a garden variety harassment case now, is going to get a lot more scrutiny from EOC than they have in the past. You've got a lot more conciliations, which is the process the EOC uses if they make a reasonable cause finding. They have to try to settle it under the law. You've got more monetary awards through settlement and through litigation. And you've also got a lot more interest. The EOC said that visits to the website on harassment more than double compared to last year. So people are very aware of this, and you need to be aware of that in terms of how you manage your workplace and how you have a heightened sensitivity for harassment type issues. Now, I thought I would throw this in. These are some recent jury verdicts. This is one in New York last year in March, about a year ago, $13.4 million. I've got a few of the facts here just for your viewing pleasure. This was a case where there was ongoing harassment that occurred over a period of a couple of years. The company allegedly did an inadequate investigation, didn't do anything about it. The person got disciplined. So you had all the factors here for a really bad case. Now, because of Title VII, you've got some caps on damages, but under the state law, many states don't have those types of caps. So the key here is you had something going on for a long time, which the employer either turned a blind eye to or didn't nip in the bud quickly. In those cases, you always end up with big damages. Female firefighter awarded $11 million in Cook County, Illinois. It's always, and I've seen this a lot. You've got females working in what I would call, traditional occupations where mostly men have had those jobs in the past. So if you're an employer that has that type of workplace, you've got to really be very mindful there, because you have a lot more. It's more of a toxic atmosphere. Things can happen. This person complained, was written up. These people were allegedly looking at pornography in the workplace, making lewd comments about the firefighter, which that's a sort of unique situation where the firefighters actually, sleep there and stay there. And so there's just a lot more opportunity for things to happen. And there was also retaliation in the case too, but that's another example. This was just in October. And here's another example too. This was not sexual harassment. This was harassment based on ethnicity. It just shows that harassment, we're focused on sexual harassment because of the Me Too movement, but other kinds of harassment can happen. It can happen because of somebody's ethnic background, religion, national origin. This person, they made fun of this person allegedly because he didn't speak good English. He was penalized, disciplined. So be aware, be sensitive about all types of harassment, and your harassment policy should not only appropriately talk about sexual harassment, but also prohibit other kinds of harassment too. So what can you do about it? Well, obviously, having a written harassment policy, that's absolutely essential, and you should update it periodically, because while the law is fairly well established, there are new cases that come up, so you should stay on top of that and have it updated. If you have an attorney who helps you, let them look at it periodically. It's just a good rule of thumb to follow. Fraternization policy. A lot of employers have policies that say people, particularly supervisors, shouldn't be dating subordinates. I think that's a helpful policy to have to show the seriousness that the employer takes these kinds of things. It's also helpful if you do get sued, or you can go back and say, yeah, we had this policy and we did enforce it. We weren't aware of this. Training, some states mandate harassment training. I think it's good to do it at least once a year. At Fisher Phillips, we do a lot of that for our clients. typically for management. I've also done training, for rank and file employees. It's a different type of training that you do, but if you want your employees to be aware of the policy, and if you do that, if there are things going on, you want them to complain. So if you do the rank and file training, which not all employers want to do it, some employers, find that to be good as well. Reporting procedures, you always want to have multiple avenues for people to report harassment, certainly not just to the supervisor. Sometimes the supervisor is the person doing it. You always want HR to be involved because you as HR professionals, have special training to know how to investigate these things. So you always want to be part of any complaint procedure. And also investigations. HR is always, once again, eminently qualified to conduct those investigations. As a defense lawyer, I typically don't conduct investigations anymore because I want to be able to represent the client if a lawsuit gets filed, but I'll provide guidance behind the scenes to clients on how to do it when they have questions and kind of direct it from behind the scenes. But you need a prompt investigation, you need a thorough investigation. It doesn't have to be perfect, but if it does turn into litigation, you want somebody who's going to look at it down the road and say this employer was thorough, prompt about it, and took it very seriously. Remedial action. If you do find that the harassment occurred, if it's corroborated, through witness statements or, through, surveillance tapes or whatever, text messages, you want to take appropriate remedial action. It doesn't always have to be firing the person that did it. If they have a stellar work record and maybe they've never had problems and this was more of a he said, she said kind of thing, you might want to give them a written final warning. But you need to figure out what's the most effective thing we can do to prevent this from happening in the future. So it's all very fact driven. There's no cookie cutter approach to it. It just all depends on what you find in your investigation. And you also need to monitor the workplace. You need to be out talking to people, walking around. People need to see, management in the workplace. Also, HR professionals need to get out and make themselves known so people can pull them aside and say, hey, I've got this going on. Because you don't want people afraid to approach HR. You want to be welcoming. Because HR has a bit of an odd role in the organization. You're there to, sometimes you have to call out, people on the operational side, when things happen. So be in the workplace, let people see you out there. And then love contracts. That's something that's been around for a long time. It's basically a way to memorialize that a relationship is consensual, to document it. That way that it's not an unwelcome situation. And you also put in there that if it becomes non-consensual or it ends, you need to be made aware of it so you can kind of monitor it. The policy against harassment, once again, the employee handbook. If you have a multilingual workplace, consider publishing it in other languages. Don't make it too legalistic. As a lawyer, I fortunately do a lot of speaking and writing for HR professionals, so I try to avoid legalese, but there's some legal language that has to be in there, but try to make it understandable and give good examples. And don't ever promise confidentiality, because you can't promise not to tell someone, because you have to conduct an investigation if you get a complaint. So never promise that, but just try to keep it on a need-to-know basis, and it certainly doesn't need to be disseminated to people who aren't involved, who don't have any interest in it. Clear procedure for reporting concerns. Once again, HR always needs to be an option. You should need to train your supervisors and other managers that if they get a complaint, they need to come directly to HR. The worst harassment case I ever had was a case where a supervisor was aware of harassment, didn't report it, and we didn't find out about it until the lawsuit was going on, and I was preparing the guy for his deposition. He was a former employee. So that created a lot of problems for us in the case. So have clear procedures. And the no retaliation policy has to be well stated in your policy, because a lot of people, you see this all the time. They say, well, I didn't report it because I was afraid it would I would lose my job or whatever. So that has to be stressed. That has to be stressed to people. There is no retaliation, and if you are investigating and the accused person, hopefully they're put on some paid administrative leave while you're investigating. But if you get some retaliation, you got to address that immediately. And it's also a good idea to redistribute the policy on a regular basis, just to keep it fresh in people's minds, and especially if you have any changes to it. You need to keep people aware of it. Have it on if you have a firm intranet, you need to have a policy there. And also, I would always distribute any changes of policy to people, give them a hard copy and have them, sign off on it if they've received it. Fraternization policy, I think this is a good policy to have. You don't want people dating people in the same chain of command. And you want to have the right as an employer. You don't want relationships going on that create a conflict of interest, that create disruptions in the workplace, or create any type of other concern, a safety concern. Those are all valid management things that companies are responsible for. So don't be afraid to exercise that right just because you may ruffle somebody's feathers. It's important to just have good, clear policies that people understand. Now, the training, once again, we do a lot of this at Fisher Phillips. A lot of HR consultants do it, and a lot of companies do it internally. There are a lot of different ways to do it, but you want to go and make people aware of what always go over the policy and say this is our policy and put it on a PowerPoint and have them look at it. Most importantly, you've got to stress the managers and supervisors that they have to take action when they get a complaint. They can't sit on it. They can't promise somebody they're not going to, act on it. If somebody comes up, you've got to do it because that's very, very dangerous. In fact, people need to be told, you get a complaint, don't bring it, you're going to be fired. You've got to really, really scare them up to get them to act appropriately. Let them know that violation of the policy can end in termination, which is not only potential personal liability, but can result in them losing their job. And they can't retaliate. Sometimes people make allegations that aren't meritorious, and none of us, any of us in life that have been accused of something, not necessarily sexual harassment, but you get angry about it, so they have to understand they can't retaliate. Employees, once again, some companies do rank and file training. Now, people typically do it when they're during their orientation. They're told about the policy, but the same kinds of things need to apply there during orientation, and if you do training periodically. Let them see the policy, let them know what the reporting procedures are, and let them know that retaliation is not going to be tolerated by the company. Once again, multiple avenues for reporting. HR needs to be included. There are a lot of us that think it's not good to list first-level supervisors just to avoid this possibility they're not going to report it. I think most policies probably do include first-level supervisors unless that person is the one doing the harassing. The key is to get everybody to report things to HR in one way or the other. And supervisors and managers need to understand that they need to escalate these complaints immediately. They don't need to sit on their hands and wait till the next day. They need to do it immediately. They need to call, their HR manager at home that night or send them a text. Well, preferably call them up, not send them a text and let them know that's what they need to do. Once you do get a complaint, it's imperative that you investigate it immediately. Sometimes you might get a complaint on the weekend, but you need to start investigating it, if you can that weekend, but if not, at least on Monday, you open the investigation. And it's there are some cases that say, well, somebody complained, but they said, well, I really don't want you to investigate because I want to try to handle this on my own. There are some cases that say where that happened and the employer followed up and said, hey, is everything okay? And then the person later sued. The employer wasn't liable, but I think the best practice is to always investigate, even if the person tells you not to, because people change their mind down the road, particularly if they get fired or something happens. And if somebody witnesses something, even if they're not the target, they need to report it too. So employees I think some people refer to as see something, say something. I think that's a practice, something that needs to be, people need to do. Now, prompt remedial action, you need to complete your investigation. You need to have all the facts in front of you before you take action. But once again, the standard is it's reasonably calculated to end the harassment, and it's not a cookie cutter approach. It all depends on what you found, the work records of the people. If you get into a swearing match situation where you don't really have witnesses or some other type of objective, documentation or surveillance or something like that, or text messages to substantiate it, then, you need to counsel the person that's accused and say, well, we couldn't substantiate this, but, a complaint was made, and we're going to make a notation of this and put this in your file, and you can't retaliate against the person, so you need to document the fact that you had a discussion with a person. I always think it's a good idea to give them a copy of the harassment policy and have them initial it. And then if you have situations where somebody's guilty of harassment, maybe a verbal harassment, which was just inappropriate, but it wasn't physical touching or what I would call egregious situations, consider some training for those people, particularly if they're upper management people, so you can document the fact that you've not only counseled them and maybe disciplined them, but you've also sent them for training. And there are a lot of HR professionals that do that one-on-one training. I always tell the complaining party that what you've done, and follow up with that person. Even if you can't substantiate it, follow up with the person in the workplace and see how they're doing. Just make sure there's no retaliation going on, and be sure to document all steps, every step that you take, so you have that, because you get into a lawsuit over it, it's good to have a good file showing what you did. And I've always found SHRM has a lot of good resources for that. If you're a SHRM member, you have access to a lot of documentation they have, so that's a good resource for you. Now, once again, monitor the workplace, periodically look and see what's going on. Look for things like clicks. Do you have clicks of people? Sometimes that can be addictive. Something's going on. Increase in turnover. That often goes hand in hand with harassment going on. You have supervisors. Sometimes supervisors get promoted up in the ranks, and so they're not really trained very well. They want to buddy with the employees under them, but they can't do that and be a supervisor. So they have to learn. They have to enforce the policy, even if it's against people they used to work with. And another dangerous area is the blurring of work and social relationships. After work, you go have drinks together, whatever. It's hard to draw the line sometimes, so that's a danger. Now, also text messaging. I think it's a bad practice for supervisors to text with their employees, anything other than maybe the employees sends them a text saying, hey, I'm going to be 5 minutes late or something for work. But in a lot of the cases I've had, you've had text messages that had, some stuff that really looked bad and, created problems for the employer. If you do have a written policy and you enforce it consistently, if you do get sued, you've got a good defense for punitive damages. You make good faith effort to prevent harassment, because that's really the whole idea, is to prevent it. You don't want it to happen in the first place, but if it does, but if you get sued for it, I mean, sometimes people do file suits that don't have merit, but you can go point to all these things that you're doing to help you. But the love contracts, we talked about that earlier. There's an example there, a link to an example. But some people don't use those, some do, but I think they're probably a good idea. It's just another type of documentation you have that shows you that the relationship is consensual. And later on, if they make a complaint, you can rely on that to help. So what are the top 10 things? Managers shouldn't talk about physical attributes. Don't use names like honey, darling, stud, baby, terms of endearment at work. Call people by their names. Discourage physical contact. Sometimes if you hug somebody who's been out sick and comes back, if you give them an appropriate hug, that's probably okay, but you want to avoid things like patting on the rear and types of horseplay. In fact, we had a pretty big same-sex harassment case at federal court in Tennessee where the company got hit with pretty big damages, where a male employee was being harassed by other male employees. It was more in the form of horseplay, but the court found that that was rose to the level of sexual harassment. Fraternization policy, let them know that policy, if you have one, which I would encourage you to have, let them train them on that policy. Once again, if the relationship does break out, it's a consensual thing, they need to report that and memorialize that with a love contract. But you also don't want to, if you've got somebody in a dating kind of relationship in the supervisory chain of command, they really don't need to be making decisions about that person, because that, once again, it's hard to be objective if you're dating somebody that you're also evaluating. Managers shouldn't call subordinates at home, go visit subordinates, once again, unless you've got this love contract in place, because it's all manner of things can happen. I've had a lot of cases where people have complained, I got calls at home and inappropriate things were said. But once again, too, evaluate the workplace, be out there with your eyes open to see if things are going on, make yourself available. We talked about this. Never agree to keep things just between us. If somebody complains, they need to understand that any complaint has to be investigated. And certainly never ignore rumors that you hear about things going on, because while they're not 100% true, many of them can be true. So you need to act accordingly and look into it. Once again, harassment rules apply to any protected status, and here are some that are listed. Anything that the law regards as a protected characteristic is fair game for harassment. You can see it happen in religious harassment, where somebody belongs to a religious group maybe that's different from what other people belong to, and they can get harassed too. So be aware of that. The final danger of retaliation. Nearly 50% of all charges are harassment or retaliation now. Even if they have a non-meritorious harassment claim, if they complain and something bad happens, they can claim retaliation. And sometimes a lot of that depends on the timing. If they make a complaint and they get fired later, you've got to come in and say, well, look, this person was a bad employee. We've had write-ups and all that. So you've got to really have your documentation in line if you make a decision to terminate somebody or discipline somebody close in time to them making a complaint. And retaliation not only applies to these things that we refer to as tangible job actions, but the standard, actually, the Supreme Court has said, is any material adverse action that would discourage a reasonable employee from filing an EEOC charge. So for retaliation purposes, the legal standard is it doesn't have to be a tangible job action. It can be something else, something less than that. And they do sort of go hand in hand with harassment claims. And they also apply to, the Supreme Court said that if you're interviewing a witness during an investigation and they claim that they were harassed, that they're protected too. And if they're disciplined, they potentially could have a claim for retaliation. So anyway, Marvin, I think we're out of time here. It's 3 after 12 by my time. Do we have any questions from anybody?
I don't see any offhand. Are there any questions? Okay, maybe not.
Well, if anybody has any questions when this is over, or my emails on the PowerPoint slide, Marvin's is as well. So feel free to email me questions that you have, and certainly would be happy to try to respond back to you. So thanks so much for attending. Thanks, Marvin, for letting me participate today. And
if you want to go ahead and hit that Change Presenter button, and I'll put up the slides for the SHRM and the HRCI credits. And I'll leave them up there for a minute when I get them so that you can write down the codes. While you're hitting buttons there, Greg, I do want you to know that somebody didn't ask a question. They put a statement in there at the end and saying, thanks, it was all pretty clear.
Good.
Do you see the change presenter thing on there so I can put the slides up?
You know, I don't see it, Marvin. It's not popping up.
Okay, I'm not sure what the problem is on there. You have Greg's, oh, maybe we're going here, let's see. And they are seeming to be lost somewhere here. We're having a little technical glitch with our webinar software. You have Greg's email address up on the screen. Mine is marvin@hrsimple.com. Not too hard. MARVIN at hrsimple.com. If you want the SHRM and the HRCI codes, go ahead and email me. I will email you back with them. Also, if you want slides from the presentation, we'll also be able to send you all the slides if you ask for them. And I want to thank you, Greg, for taking the time to do this for us.
Oh, it's my pleasure. Thanks so much. Everybody have a great day.
All right. Everyone will see you all in March for March's webinar. You take care.